Hey, we're going to be answering the question today. Can you get arrested for providing a false report? Specifically, in a family violence case, if you've made a report that family violence has occurred, will you get arrested by the police if you say later that no, it didn't occur? What's your thoughts on that, Luis?
More likely than not, you're not going to get arrested for coming back later and, let's say, offering a different version of whatever was initially reported at the beginning of the case.
This is pretty common, right?
It's very common from both sides, even. I think just given the dynamics at play in a family violence case, different people's level of temperament for discussions and different things between people in relationships, it's very common for in family violence cases on both sides of the case for things to change and people want to clarify their statements or not participate with court proceedings and things like that.
So, yeah, for our listeners and viewers who don't know, both myself, I'm Brian Foley, so Luis Baez, we're both criminal defense attorneys, and both of us used to be prosecutors working for the state of Texas, prosecuting family violence offenses. And so, we kind of know firsthand that this almost never happens. In fact, I don't think I have ever seen somebody come back and be prosecuted who, reported a class A family violence or a impeding breath, felony family violence, and said, actually, no, that didn't happen. When I said that they strangled me or when they said that they had punched me, that's not accurate. I don't think I've ever seen somebody prosecuted for false report. Have you?
Not in the context of a family violence case. I have seen some,
Sexual assault, I've seen it.
right, exactly. Once the allegations start to get, I don't want to say more serious because even a class A misdemeanor family violence is serious enough. But once you start to go up on that scale from misdemeanors to felonies, then it has applied. And I think I've even seen cases where the district attorney's office and the prosecutors, let's say a file comes on their desk, there's a report from a complaining witness or a victim. I have seen it again based on the context of a serious enough charge to where that person will get prosecuted. But in the context of a class A assault case or family violence case, I haven't seen it. And I think that's a discussion we typically have with all of our clients at the beginning of a case like this is they'll want to know, hey, at the end of this case, if we get it dismissed, can I go back and charge this person for, can I report them for false report? Or can I file some sort of claim against them for defamation or malicious prosecution? And yeah, 100% of the time on a class A misdemeanor for assault, the answer is going to be no.
Yeah, probably not. A lot of times, that reminds me of so many times you're talking to a client about how the system really works. And it when especially if somebody's been, wrongly accused, they're like, well, how do we get justice out of this system? And a lot of times the answer is you don't. We
You don't.
just get you out of the system. I view our job many times, and I'll say this to clients, my job, you're in this system right now. Right now, the prosecutor thinks you're guilty. The police officer already arrested you. He thought you were guilty. A judge found probable cause to hold you and bring you to court to answer for the charge. And basically, when a prosecution starts, the prosecutor believes every word that the police officer wrote and what the victim said. More experienced prosecutors know that there's going to be some issues there, but especially a newer prosecutor like we have in Harris County and Galveston and Montgomery County, there's a lot of young prosecutors right now. They're just assuming what the officer said was correct, and that means you're guilty, right? So you're in this system now. Our job is to get you out by any way that we can get it to happen. We're not necessarily out to have justice served and the truth come out. That rarely happens. But if we can get you out, get it dismissed, something like that, that's the win right there. What are your thoughts on that?
Yeah, thinking back to my time as a young prosecutor, I think this is something that, you reminded me of and we made sure we applied to our work as prosecutors was the idea and frankly the law that our job as prosecutors wasn't to win every case and it wasn't to go out and convict everybody. What our job was is to seek justice. And that looks like different things in different cases. And so that's kind of what we want to focus on when we're talking about getting to the truth in a certain case like that. Like, we have to make it to where the conversation isn't about a win or a loss for one side or the other. But even on a family violence case or a misdemeanor assault case, the conversation needs to be, well, what does justice actually look like for this situation? And I think from the defense perspective, the main problem that we're dealing with is a lot of what has led to the arrest and has led to having to go to court is someone's word. So the question is this person making the complaint about assault, is their word sufficient to justify an ongoing, a drawn out misdemeanor assault case? And so that's where it becomes an issue, I think, for us to overcome. Is that's what they are relying on. The advocates for the state of Texas, the prosecutors, they're relying on someone's word. And so our job is going to be, okay, well, is that word credible? And that also brings up, and tell me what you think about this, but that does then lead us to issues or questions of how in Texas do we even define the word assault? And that's why we get stuck in these situations where cases can't get dismissed right away. Ideally, over time that they do, but there are a couple of different barriers like that when it comes to misdemeanor assault cases.
Yeah, I mean, so a misdemeanor assault case, all that you have to show in Texas is that the person had bodily injury, which includes any pain at all. No mark is needed, no scratch, no red marks. Now, those would count. A scratch or a visible injury certainly would count as bodily injury, but certainly doesn't have to be a very serious injury, and you could have up to a year in jail on an assault, family violence misdemeanor. One thing I wanted to say here was also this: we've kind of been skirting around this idea of like the false report. If you recant your statement, prosecutors almost expect a family violence victim to recant. And even true victims will recant their statement if they're under the power and cycles of control. They have a whole literature on victimology. You know, I was a prosecutor, and when I've prosecuted these kind of cases, sometimes I would call a family violence expert as a witness to talk about the cycle of violence and why somebody might recant a statement. But oftentimes, all the little check boxes, there's maybe 10 or 15 sections to the power and control wheel. None of them are present. And somebody's recanted because things just got out of hand. And so, as a prosecutor, you wanted to use evidence-based prosecution. Did you use that and find that helpful?
I did, primarily because it's a way of making sure that we're staying objective about the case, where we're not letting any biases, even from, like, let's say personal experiences or things that we were looking at or had been a part of before becoming prosecutors. So I felt like it was always helpful to really reframe the case from a objective perspective and what that might look like in the context of a jury trial or a bench trial.
Yeah. And if you got, 4 handprint bruises on a neck, that's pretty good evidence for a strangulation, unless there's a video showing that's clearly in self-defense. But, both of those things, a mark, a video, things like that, those are objective pieces of evidence. And so family violence cases, the best way to prosecute those and defend them, honestly, is to rely on those objective, evidence-based 911 call. People are going to be listening to that, see how they sound on that, photos and things like that. So when we start a defense of a case like this, we're always telling our client, well, it doesn't matter. The state doesn't have to dismiss a case just because the victims filed a non-prosecution affidavit.
Right.
They can continue, and they will continue if there's evidence of it. And so sometimes our job is mitigating the damage and the punishment. And other times, when we can show that there's no proof beyond a reasonable doubt, then our goal and our job is to get it dismissed.
Right. And a lot of times when we deal with, let's say, a DWI case, one thing that we have to tell the client is, all right, well, we have this DWI case, but now there are all these other things that we're going to have to address and take care of for you, like your driver's license, maybe conditions of bond. The same thing goes on in a misdemeanor assault family violence case with things like protective orders, conditions of bond. I mean, I remember even as a prosecutor realizing, okay, there are certain parts of the family code, the Texas family code now, that I have to dig into to know how to address this criminal law case. And so it's one of those things where a call a report for a misdemeanor assault or a family violence charge turns into a lot of other barriers that need to get addressed.
Yeah. You could have a protective order that kicks you out of your own home for 61 days on a misdemeanor, 91 days on a felony that involves a deadly weapon. And a lot of times people are like, well, I haven't even been found guilty yet. Can the judge do this? And the answer is, well, we've fought it as many times as you can basically try. And the courts have consistently held that protective orders are valid. You can be kicked out of your own home. And even when the protective order ends up running out after 61 days or 91 days, you may have a bond condition that says if you violate it after that time period is up, you still go back to jail.
Yeah, and then it's kind of like with DWIs. Let's say you have bond conditions or something like that, and you violated a bond condition. Well, you and your attorney are going to talk about how to address that violation with the judge, how to make sure you avoid those things in the future. When it comes to misdemeanor family violence cases, if you violate a bond condition in a family violence case, that could be a separate Class A misdemeanor. But violating a protective order in a misdemeanor family violence case can be another thing that you could get charged for. So you have to navigate these very, very carefully. And let's say, for example, you were served with a protective order at some point while you were in the jail before you were released. Well, if you knew with 100% certainty that, hey, this other party, whether it was a roommate or a family member, they don't live there anymore. Let's say they took off to Oklahoma or Arkansas. They just want to get as far away as possible. Maybe not because of anything with the client. They just want to not deal with it. Well, you still cannot go back to that address. Things like that are the reasons why you want to get an attorney, just to make sure you don't find yourself in more trouble down the line.
Yeah, and that goes back to the old adage, which is true. Ignorance of the law is not an excuse. That's why you should have an attorney who is not ignorant of the law who can help you out. Thanks, everybody, for tuning in. And as always, if you like what you saw, don't forget to like and subscribe, share, ring the bell for notifications, and we will see you next time.